DOJ says AI set your rent, and that's a cartel. Landlords say the algorithm set the rent, not them. But the Department of Justice has filed a civil antitrust complaint, arguing that outsourcing that decision may be the coordination itself. The platform is called YieldStar. It was built by a property technology company called RealPage. Its rent pricing products are used to manage pricing decisions for over 4 million units across the United States. The system was marketed as optimization. Landlords described it as a tool, not a decision. According to the federal complaint, the Department of Justice is arguing something different. It alleges the platform may have used confidential competitor data, non-public pricing information, to align rents across rival landlords in the same markets. If that legal theory holds, the case may redefine how antitrust law treats algorithmic pricing systems. And it raises a question that extends well beyond the rental market. If you deploy a shared algorithmic tool in a concentrated industry, are you making a business decision? Or are you participating in a coordination structure you never agreed to join? The system and the allegation. RealPage acquired the YieldStar revenue management system in 2002. By the time regulators began examining the rental market, the platform had been integrated into RealPage's pricing product suite for over 2 decades. The pitch was straightforward. Property managers are operating in real time. Occupancy shifts, markets move. A system that aggregates data and generates pricing recommendations is faster and more consistent than a human analyst working from a spreadsheet. But here is where the federal theory becomes significant. The complaint does not allege that executives in competing companies called each other, exchanged pricing data directly, or agreed in any conventional sense. The allegation is structural. It is that the platform itself, because it aggregated non-public competitor data and distributed pricing recommendations back to all participating landlords, may have functioned as the coordination mechanism that antitrust law was designed to prohibit. The landlords individually may have believed they were following software. The Department of Justice in its complaint is arguing that following the same software when that software is fed by confidential data from your competitors may not be a defense. It may be the conduct. State enforcement, the AG settlements. Before the Department of Justice filed its federal complaint, state attorneys general had already begun to move. The North Carolina Attorney General reached settlement agreements with 2 major residential landlords, Greystar Real Estate Partners and Cortland Management, over their use of algorithmic pricing tools. Both cases resolved through consent orders. Those consent orders required the companies to modify how they use shared pricing platforms. Critically, both settlements included the appointment of a court-supervised monitor, an independent oversight mechanism with authority to verify compliance. The Greystar settlement reached $7 million. These were not warnings. These were enforcement outcomes with financial consequence and structural compliance obligations. But here is what the state settlements did not resolve. The consent orders addressed the landlords. They addressed the users of the platform. The software vendor, RealPage itself, remained outside the scope of those state resolutions. The question of vendor liability, of whether the company that built and operated the platform carried its own antitrust exposure, was still open. That is the question the Department of Justice picked up. The court-appointed monitor signal. The appointment of a court-supervised monitor is not a standard feature of a regulatory settlement. It appears in consent decrees when regulators have concluded that behavioral promises, commitments to change practices going forward, are insufficient on their own. A monitor signals that the regulator does not trust self-reporting. It means independent verification has been judged necessary. In the context of algorithmic pricing enforcement, it carries a specific implication. The mechanism itself, not just the conduct of the individuals using it, is being treated as a structural problem requiring ongoing oversight. The state enforcement layer established that landlord exposure was real. It established that shared algorithmic pricing systems had drawn regulatory scrutiny serious enough to produce consent orders and court-supervised compliance monitoring. What it left open, and what the federal complaint is now addressing, is whether that exposure extends upstream. Whether the company that built the coordination mechanism, maintained the data infrastructure, and delivered the pricing recommendations to competing landlords carries independent antitrust liability. That is what the DOJ complaint is testing. The federal complaint, vendor liability. In August 2024, the Department of Justice and 8 states filed a civil antitrust complaint against RealPage in federal court in the Middle District of North Carolina. The complaint names the vendor, not the landlords who used the platform, but the company that built it, operated it, and distributed its recommendations to competing clients in the same markets. This is a doctrinal move. The conventional antitrust enforcement target in a price-fixing case is the parties who agreed. The conspiracy, the executives in the room, the emails. RealPage and its clients described the platform using the vocabulary of optimization, revenue management, market intelligence, yield enhancement. These are the terms that describe a tool that helps a single business make better decisions. The Department of Justice in its complaint is using a different vocabulary: coordination, horizontal price fixing, shared mechanism. These are the terms of antitrust law, terms that describe what happens when competing businesses align their pricing through a common structure, regardless of whether they ever communicated directly. The question the complaint poses is whether the YieldStar platform, by aggregating non-public competitor data and returning pricing recommendations to all participating landlords, functioned as the equivalent of that direct communication. The Sherman Act and Algorithmic Coordination. Section 1 of the Sherman Act prohibits combinations and conspiracies in restraint of trade. For most of the law's history, that has meant human agreements, explicit or implied, between competitors. Here is a structural analogy that captures what the DOJ theory is attempting. In the 19th century, telegraph operators for competing railroads sometimes shared routing and pricing information through the telegraph network itself, not through direct meetings, but through the shared infrastructure. Courts eventually found that the network's role in enabling coordination was itself a problem, regardless of whether the executives ever sat in the same room. The DOJ theory in the RealPage case is structurally similar. The shared platform, the mechanism through which competing landlords' non-public pricing data flowed and from which coordinated recommendations emerged, may itself be the coordination act the law prohibits. The algorithm did not make the agreement, but the complaint alleges it may have functioned as the agreement's infrastructure. The presence of court-appointed monitors in the state's settlements reinforces this framing. Regulators did not simply require landlords to stop using the software and move on. They imposed structural oversight, independent verification that the mechanism was no longer operating as alleged. That is the signal of a regulator who believes the problem is architectural, not behavioral. Enforcement theory, moving upstream. The RealPage complaint represents a shift in how antitrust enforcement is being applied to algorithmic systems. Previous enforcement in algorithmic pricing cases focused primarily on the users, the companies that deployed the tools. The theory was that executives who chose to adopt a shared pricing platform, knowing it aggregated competitor data, were participating in a coordination structure. But the federal complaint goes further. It names the vendor. It targets the entity that designed the data aggregation architecture, that maintained the competitor data flows, and that distributed the pricing outputs to clients who were, simultaneously, competitors in the same rental markets. Under this theory, building and operating the coordination infrastructure carries its own antitrust exposure, separate from the exposure of the companies that used it. That distinction matters for every technology company that operates shared data platforms in concentrated industries. The question is no longer only whether your clients are coordinating. It is whether your platform is the mechanism through which they do. The professional exposure map. The RealPage enforcement architecture, federal complaint, state consent orders, court-appointed monitors, creates a governance consequence that extends beyond the rental market. Consider the position of an executive at a company that adopted YieldStar. The decision to deploy the platform was a business decision. It went through a procurement process. It may have been reviewed by legal. It was approved. Under the theory being litigated in the DOJ complaint, that approval decision is now the point of exposure. The defense available to those executives, the argument that the algorithm set the price, not them, is precisely what the DOJ theory addresses. The complaint does not allege that executives made pricing decisions consciously. It alleges that the decision to deploy a shared platform that aggregated competitor data and distributed coordinated recommendations was itself the conduct. Under the theory currently before a federal court, the algorithm's role is not a mitigating factor. It may be the mechanism that establishes the case. The algorithmic cartel problem. What the RealPage case is testing is whether a new category of corporate fraud exposure exists, one that does not require the smoke-filled room, the encrypted message, or the handshake agreement that antitrust cases traditionally relied upon. What regulators appear to be arguing is that an algorithmic cartel, a pricing coordination structure achieved through shared software rather than direct agreement, carries the same legal risk as its human equivalent. The mechanism is different. The outcome the law is designed to prevent may not be. That theory has not been adjudicated. The DOJ complaint is a filing, not a verdict. RealPage disputes the characterization entirely, but the state consent orders have already demonstrated that regulatory exposure under this theory is real. Real enough to produce settlements, court-supervised compliance, and a $7 million enforcement outcome against one of North Carolina's largest landlords. The forward arc, beyond rental markets. The RealPage enforcement action is specific to the residential rental market, but the legal theory being tested is not. Algorithmic pricing systems that aggregate non-public competitor data and distribute coordinated recommendations to competing clients exist across commercial real estate, hospitality, logistics, and financial services. The question of whether shared data infrastructure in concentrated industries constitutes coordination under antitrust law is not unique to apartment rents. Under the theory currently before a federal court, that review is no longer optional due diligence. It is the kind of professional standard that enforcement outcomes tend to establish retroactively, and this case has not yet reached a verdict. For executives who have approved algorithmic pricing tools, for legal and compliance teams advising on those deployments, and for technology companies that operate shared data platforms in concentrated markets, the RealPage case is the enforcement signal that this question is now active. The Department of Justice did not file a criminal complaint. This is a civil antitrust action. That distinction matters for how the exposure is characterized. It is regulatory and civil litigation risk, not criminal prosecution at this stage of the proceeding. What the case establishes, regardless of how it ultimately resolves, is that the enforcement apparatus has concluded the theory is viable enough to bring to federal court. The complaint names the vendor. The state settlements named the users. The court-appointed monitor architecture signals structural concern. The Greystar settlement produced $7 million in enforcement consequence. Each of those elements is already on the record. The open loop planted at the start of this analysis was this: Landlords say the algorithm made the pricing decision, not them. The Department of Justice is arguing that is exactly the point. Under the coordination theory in the federal complaint, deploying the mechanism may be the decision the law is examining. That loop is not closed by a verdict. It is closed by the filing. The legal question is in front of a court. The governance question, what it means to deploy shared algorithmic systems in concentrated markets, is in front of every executive whose company has done it. ScamBeast analyzes corporate fraud patterns and governance failures using primary regulatory sources. Follow ScamBeast if you work in finance, tech, or leadership. Full sources and documentation are in the description.